Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of BBA LLB from Bharati Vidyapeeth New Law College, Pune. And today's topic is judicial activism, and the purpose of this video is to create awareness about this topic. So let's start the topic. It is claimed that in many recent judgments, the Supreme Court has become hyper-activist in making laws. Neither is the broad separation of powers among the three organs of the state maintained, nor is the law being preserved. In Ram Javaya vs. State of Punjab, 1955, the court observed, our constitution does not contemplate assumption by any organ or part of the state or functions that essentially belongs to another. This implies that there should be a broad separation of powers in the constitution among the three organs of the state, that is legislative, executive and judiciary, and that one organ should not encourage into the domain of another. If this happens, the delicate balance in the constitution will be upset and there will be chaos. So what is judicial activism? The judiciary performs an active role to uphold constitutional values and ethics under the constitutional pattern. For addressing civil dilemmas, the judiciary applies its intellect and creativity to fill the gap between the positives and normative aspects of legislations. For this reason, judicial activism has emerged. The term judicial activism refers to the court's decision based on the judge's personal wisdom and does not go rigidly within the text of the statutory passed by the legislature and the use of judicial power broadly to provide remedies to a wide range of social wrongs for ensuring proper justice. So there are some pros of judicial activism, and these are as follows. It provides a system of checks and balances to the other government branches. Judicial activism is a delicate exercise involving creativity. It brings out required innovation in the form of a solution. Judicial activism provides judges to use their personal wisdom in cases where law fails to provide a balance. Judicial activism also provides insights to the issues. The reason why this is a good thing is that it shows the instilled trust placed in the judicial system and its judgments. Many a time public power harms the people, so it becomes necessary for the judiciary to check misuse of public power. It provides speedy solution where the legislature gets stuck in the issue of majority. So now we will discuss about the cons of the judicial activism. The first and foremost con and the most important cons of judicial activism would be that judges can override any existing law. Hence, it clearly violates the line drawn by the Constitution. The judicial opinions of the judge become the standards for ruling other cases. Judgment can be influenced by personal or selfish motives, which can further harm the public at large. Repeated interference of courts can erode the faith of people in the equality, integrity, and efficiency of government institutions. Court limit the functioning of government when it exceeds its power and stop any misuse of power by government agencies. Some of the examples of judicial activisms are in 2017, Arun Gopal versus Union of India. The Supreme Court fixed timings for bursting Diwali fireworks and prohibited the use of non-green fireworks, although there are no laws to that effect. The second case would be MC Mehta versus Union of India 2018. In this case, the court annulled the statutory rule 115 subclause 21 of the Central Motor Vehicle Rules 1989, when it's directed that no BS4 vehicle should be sold after March 30, 2020, and that only BS6 vehicles can be sold after that date. The next example is Subhas Kasinath Mahajan versus State of Maharashtra 2018. The court amended the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 by annulling Section 18, which said that no anticipatory bail will be guaranteed to a person accused under this act, by requiring a preliminary inquiry and by prohibiting arrest under the act except with permission in writing by the appropriate authority. So the conclusion of this topic is that judicial activism is not backed by the constitution. It is a product devised solely by the judiciary. When the judiciary steps over the line of the powers given to it in the name of judicial activism, one can say that the judiciary then begins to nullify the concept of separation of powers specified in the constitution. Judicial discipline has to be observed to maintain a clear balance. Making laws is the function of the legislature. It is a duty of the legislator to fill the gaps of law, and it is a duty of legislator to implement it in a proper manner, so that only the interpretation remains as a work for judiciary. Only the fine equilibrium between these organs of government can sustain the constitutional values. That's all for the topic today. Thank you and have a nice day. Please like and share the video and subscribe the channel. Thank you.